Welcome to the Pioneers in Pixels audio podcast, hosted by Sanjay K Khetarpaal, CEO of Marketing Markers, a digital marketing agency. Here we have discussions with some of the leading attorneys. Disclaimer: the podcast is for educational purposes. Please reach out to attorneys for legal advice.
Hello, everyone. This is Sanjay K Khetarpaal, and I'm a digital marketing agency owner based out of Englishtown, New Jersey. And this is my podcast where I try to bring all the pioneers of their businesses industry. Today, I have Jason. Welcome, Jason.
Thank you, Sanjay. Great to be here.
Perfect. Fantastic. Jason, why don't you tell the listeners about who you are, what you do, why you do it? I'd like to hear your story, that how you got into what you are into right now.
Absolutely. So, Jason Meyer, and I am the founder of a law firm based out of Princeton, New Jersey, but with clients really all over the country. And the name of the law firm is Meyer Business Law, because my name is Meyer and the kind of law I practice is business law. So brilliant branding on my part. But the road that took me to Meyer Business Law is really a road of entrepreneurship. And the law firm is one that I created to serve entrepreneurs, to serve people who are running businesses and running businesses really as their passion. So I went to Princeton undergraduate, was in the radio business for a few years, and then went to University of Pennsylvania Law School. And then I spent 10 years in sort of big East Coast brand named law firms doing the big law firm thing. But in the middle 90s, I stepped out of the practice to start a company with my wife that was a legal education and news company selling products by subscription. The whole story behind that. But we ran that business for 13 years, angel and venture funded, 25 employees at its peak, actually ran what was the second largest intellectual property law news service in the country. And when that came to its logical end, I shifted to working not as a litigator, but as a corporate lawyer, because I had just finished 13 years of being my own in-house counsel. Mm-hmm. And I became an in-house counsel for other people. But the companies where I worked were all privately funded, sort of what you would call emerging growth or the sort of typical venture growth curve companies, which both happen to be in the corporate compliance and education space. One was a company based here in Princeton, with worldwide clients, both software and education products. And then I was general manager for a $50 million business unit of what at the time was the largest provider of corporate ethics education in the world. So spent time as a big firm litigator, as running my own business, as helping other companies run by being in their C-suite, being a general counsel or a general manager. And when the next turn in my career came, I said, I want to go back to the practice of law full time. But what I want to do is practice law for the people who had a journey like mine, for entrepreneurs, for people whose passion is running and building a business. I think running a business is the most satisfying intellectual puzzle I've ever encountered. It really is the expression of oneself through what you can do for other people. And I wanted to be an engine for growth for entrepreneurial companies and help those companies use the law and the things that the law does, not merely as keep me out of trouble, Jason. So obviously I do that, but also as an engine for growth, as a way to propel that growth and to make their life as an entrepreneur less stressful and more successful. And that's really the mission of Meyer Business Law.
I love it. Actually, it's fantastic. I love that. Jason, I was looking at your website and everything. Like, you do a lot of stuff: business formation, governance, deals, transaction, business contract, employee contract relation. There's a lot there, which is very good. But there are a few areas I would like to jump onto real quick, because what is going on. So here's one thing which I'm going to talk about the business formations part of it for a second. Pandemic, and like before pandemic or during pandemic, there's a lot of people who are working from home, and a lot of people have actually started doing something, their businesses. Not everybody has done some formations, and they were just running the businesses. So talk to us about, like, hey, if you guys are running the businesses, should I open a company, or I can just run the way I'm running it? And what are the benefits, pros and cons of all of these things? I mean, I know it's a loaded question, but there are a lot of people I met on a daily basis. They come to me and saying, Sanjay, can you create a website? And I can. And like, do you have an LLC? They don't. Now, is it a problem for me?
Mm-hmm.
Me to create a website is not a problem, but I just want to understand and just want to educate these listeners saying that you started something. What are the pros and cons of having an LLC or not? So
Sure.
You got that.
Sure. There are circumstances under which you absolutely need to have an entity, under which it would be very difficult to function without creating a corporation or an LLC, or in limited cases, things like various forms of partnership. The 8% of the time when people form an entity, when they form a company, it's either an LLC, a limited liability company, or a corporation. They are all creatures of state law. You don't have to go to Delaware. If you're in New Jersey, you live in New Jersey, your business is in New Jersey, unless you're looking at bringing in major amounts of investors, forming a New Jersey company is just fine. And there's rarely a reason to do anything else. I was saying there are times when you just have to have an entity. If you're going to have investors, if you're going to have more than one person involved in the company, as your partner, as an employee, as a worker, you really should form an entity, because you begin to accumulate legal protections and legal processes that are really not as easily available to you if you're doing it as a sole proprietor, if you're doing it just as yourself. Mm-hmm. The biggest reason to form a corporate entity, an LLC or a corporation, is what is called limited liability. Mm-hmm. And that is whether your house is on the line when you do something in your business. And if you do it through a company, an LLC or a corporation, and you use that company in the right way, you are signing your documents in the name of the company, you are making expenditures from a company account, things like that, then what you do through the company, really what the company does, usually would not result in people coming after your house. They could only come after what's in the company bank account or what the company owns. Now, there are exceptions to this. We can pursue what those exceptions are. To me, the biggest exception is if you're driving your car and you're on a business appointment and you run someone over, mm-hmm. you can't hide behind your company because you're the person who is the driver. If your employee was driving and your employee ran someone over, then it would be very unusual for whoever they injured to be able to come after you personally and your house because you were doing it through the company. So the biggest reason to form a company is for that extra level of protection. Now, it used to be in the case in New Jersey that creating a limited liability corporation, an LLC, was both pretty easy and pretty inexpensive and had very low carrying costs, $50 a year for an annual report. And I would recommend forming an LLC to almost anybody in business. There is a slight additional cost now in forming any kind of company, in that there is a new federal government filing under what's called the Corporate Transparency Act. You have to file information with the federal government about who the actual owner of the company is. And there are potential fines from the federal government if you don't do that. So that's increased the cost and risk of forming a company a little bit, but not very much, and nothing compared to what you could be out for various things that might go wrong if they went wrong on your personal account instead of through your company account.
That is interesting, because it's almost like I do recommend people to open the company, but this is hearing from you would be really good, that why they should do that. And what if they don't do it, what kind of things they get into trouble with. They own them.
You also get things, and you would know this, Sanjay, from the marketing side. You get a little bit more protection for the name you're using if it's also the name of your business. Right. There are things you may want to qualify for, benefits you might want to qualify for, government contracts or procurement programs, things like that, where it's either you need to be a company to qualify, or it's just so much easier to do it through a company. Let me give one more example, I think, Sanjay, which is a major issue in the law for small businesses is what's called employee classification. That is, should you be an employee or should you be an independent contractor? Most small businesses that start up, most brand new startups, I just saw some statistics on this the other day. Most are 1 or 2 person companies, typically providing, this is my side gig, I'm providing services out of my house, I form an LLC and I'm doing some consulting, or I'm doing some writing, or I do mechanical work on the side. It's that kind of job. Mm-hmm. To get that work, the people who are hiring you really count on you usually being an independent contractor. They don't want you as an employee. They don't want the carrying costs of you as an employee. They don't want to pay withholding. They just want to write you a check for your services.
Right.
So in those cases, the person doing the work, you, the business person, really would like to be treated as an independent contractor, and you would like your clients to have the comfort that they can deal with you as an independent contractor, and they don't need to worry about whether the state will come along and say, oh no, you should have been treated like an employee.
So it's not
if you do.
Sorry, let me interrupt you for a second. So it's not it's a 1099 from a tax perspective and not a W-2. Is that what you are?
That's right. That's right. You really should be a 1099 and not a W-2. And the reason for that is if the state comes along and says, well, you should be a W-2, really, whoever was paying you suddenly has to pay back withholding and pay tax penalties and pay workers' compensation benefits for you. And they never intended that to be part of the deal. And there are people who really should be treated like employees, and it's unfair to them to be treated as independent contractors instead of employees. Mm-hmm. That's not what I'm talking about now. What I'm talking about now is I formed a business and I really want my clients to be able to depend on me being an independent contractor. If I work for you through my company, the state does not ask the question about whether you were an independent contractor, because the biggest test of whether someone is an independent contractor is whether they have established their own independent business. Well, if you have an LLC and I'm working through the LLC, if the state ever looks at that check, the state will say, well, obviously they were an independent contractor because it was one company hiring another company. So that's another advantage in forming your own entity, which is your clients can count on you being an independent contractor.
Interesting. So you raised a good point because the world is expanding, like globalization is hitting us. So people, like when you work, like right now, digital marketing people, we're looking for the best talent, and not necessarily we find the best talent in US. We may find it anywhere in the world. Right.
Yes.
And those could be companies, independent contractors working in that location, which could be anywhere in Europe and Asia, anywhere, and vice versa. I'm hiring somebody from any other places, but vice versa, I can be working for somebody who's in UK, right? And there is no concept of 1099, or maybe I'm working in Germany, or maybe somewhere else. Like my client could be anywhere, and I can help them anywhere because the digital marketing world, it's just that I can do it digitally anywhere. What I should consider changing, like if I'm hiring people from outside or working for somebody from outside as a contractor, what changes?
Well, one thing that changes is who watches and who cares. The state will sort of watch less.
Right.
In that analysis I was telling you about, who's an employee, who's an independent contractor. When the state of New Jersey comes and checks your employment records, if you wrote a check to someone outside the state, they not 100%, but sort of 90% sort of stop the analysis there. They're not really worried about that because the person who might be an employee isn't even in the state of New Jersey. So the state of New Jersey doesn't have that much to gain by calling you an employee. There are exceptions, but I'm giving the general rule. And on all of this, something I didn't say. Everything that I say is sort of general educational advice. This is not meant as specific legal counsel to anyone. To receive legal counsel, you need to retain a lawyer. That disclaimer out of the way.
Yes.
On international transactions, particularly these sort of international side gigs, one issue to keep a close watch on is your own personal and business taxes, how you're classifying net income, the way you are reporting it, that you are being careful to report it accurately to avoid various problems that become more complex on international transactions. There are actually anti-money laundering regulations. You need to keep an eye out. You don't want to have large sums of money sort of crossing the ocean without being very careful about how you document that, how the money is flowing, really your bank having an idea of what you're doing so that they don't red flag your transactions. But the level of money laundering compliance, especially in international transactions, is pretty high. There are also background issues, and it's funny. I mean, when you would think, well, this can't touch an entrepreneur, but actually it can.
Yes, it does.
There are issues about what technology you're allowed to send outside of the United States. There are import-export restrictions on certain technology leaving the country or leaving the country to go to particular other countries. There are import-export restrictions on certain countries. And for instance, if you worked in IT, let's say you were a coder, now you're beginning to get into a world where you might have to think about, well, what is this software I'm writing? What kind of technology have I put into it? What am I shipping overseas? Each industry has its own rules about what comes in from outside the jurisdiction and whether that matters. And you do have to be attentive to that. I would say the one other thing in the digital space, Sanjay, that I'll mention specifically is pretty much every country now has its own rules and laws about data privacy.
Correct. That is true.
And the laws in places like the European Union, Japan, Brazil, they have adopted privacy laws and digital privacy laws that are actually much more stringent than the law in the United States. You could be 100% compliant with a law in the US and be heavily non-compliant with a law in the European Union. And that does matter if you really are doing any business in those places, particularly to the point where you have any assets in those places or customers that you really count on in those places. Then you need to be doing things to see what your international data privacy compliance looks like. And then the final thing and some of this is from my background in the world of corporate compliance, but one final thing to keep an eye out for that is particularly a risk as you do international transactions is international anti-bribery compliance. Things like the U.S. Foreign Corrupt Practices Act, the United Kingdom's Bribery Act. There are real limits on the extent to which you can, I think everyone knows, like, I can't go to a foreign country and the way to do business is I'm going to hand a government official an envelope full of cash. I might be tempted to do that. There may be foreign officials who won't be hesitant to ask me for that envelope of cash. But if I hand them an envelope of cash, I'm going to go and I get caught, I'm going to prison.
Yeah.
And it's sort of that simple. But this also comes up in situations like I am inviting a doctor from the European Union to come to a weekend retreat and I'll pay the expenses. Well, if that doctor is working under a socialized medicine program, therefore they could be considered a government employee or official. Now you're doing something for them which is beyond the usual. Hey, even that could be considered a violation of the Bribery Act. So there's a lot going on like that in international transactions. All that being said, if what you're talking about is there's a virtual personal assistant, someone who does virtual secretarial work, and she's based in Greece, and I found her on an online service, and I'm paying her $25 an hour for 10 hours a week.
Right.
The chances of anyone really worrying about international compliance on a transaction like that is pretty slim.
I understand. I think it makes sense. Interesting. It's very interesting, actually, thinking about all this information is great. So what I'm going to do is I'm just going to quickly shift the gears to something else because there are so many things you cover. I just want to touch upon each and every piece when I see.
Yeah.
So there's another piece which is very important is the business contracts and the clients and the vendors kind of an area which kind of intrigued me sometimes is like the thing which I always worry about, or a lot of people talking to me are like, how important are well-drafted contracts to the success of the business?
I think they are extraordinarily important. I think having the right contracts is a basic building block to a successful business.
Give me some examples of those.
This is, well, it's especially important because I meet business person after business person that's sort of like, well, I got handed this contract and I'm sure it's fine, right? Or I'll read it, or what choice do I have?
Mm-hmm.
The answer is you almost always have a choice about what's in that contract.
Right.
I will give you a few examples, but you almost always have a choice. It almost always is going to matter. And and I work in the whole, like every kind of business contract there is between the business and its employees, the business and its contractors, the business and its vendors, the business and its customers or clients, one business to another business, supply chain. I work in all of those contracts. Let me pull two examples out that I think may make the best, that may make my point best.
Okay.
One is a very typical business situation where I have a small business and I manage to get the attention of a larger business that wants me to do something for them. They want me to supply something or provide services. It may even feel to me like the big break for my company. Oh, I finally got this bigger company's attention, right? And now the big company sends me a contract and they say, this is our standard agreement, sign it, and then we can do business together. I would say one of the most frequent mistakes I see in business, in small business, is business people who just sign that contract without reading it or asking a question about it, and especially without showing it to a lawyer.
Right.
They may feel, well, I don't have any choice. I can't change it. Sanjay, I cannot tell you the number of times in my career that I have successfully gotten critical changes for my client into a bigger company's standard agreement. And I could probably count on one or two hands the number of times where I absolutely actually could not make a single change to the deal that came in a contract. Just so rare. So there are things going on in those agreements. There are when I get paid, what I have to do about returns, what kind of insurance I have to cover, what other expenses I need to provide, who bears different risks. Here's one example. I had a client who wanted to get things on the shelves of major drugstores. They finally got a contract from a major drugstore chain saying, so we'll carry your goods, right? They almost didn't send me the contract. They said, oh, let's take a quick look. It's their standard contract. I'm sure it's fine. What it said in the small print of that contract was, we can order as much of your product as we want. We will pay you for that product 90 days after we sell it.
Whoa.
And if we don't sell it in 180 days, we're sending it back to you and you will pay us a 30% restocking fee. In other words, what I said to them is, if you sign this client, the worst thing in the world that could happen to you is this major drugstore chain says, I'll take 1 million units, because you can't handle the cash flow hit of creating and shipping 1 million units and waiting 90 or 120 days to be paid for them, if you ever are paid for them. Because this drugstore chain carries no risk and you carry all the risk.
All the risk.
And it looked like a break, but it could just break your company. Right? I see these kinds of things in contracts all the time. So I really counsel business people, like, do not try to DIY that big contract. If it's critical for your business, let a lawyer look at it. It's up to the lawyer. I would say then there's a duty on the lawyer that I feel. And that duty is, I really, really, really need to try to not lose this deal for my client. My job is not to tell the client no, unless it's an absolute business killer. I might tell my client, hey, let's try and do it this way. I might tell my client, what can we do to mitigate this risk? I might say to the client, before you sign that, let me really try and get this provision changed. But I'm really going to try not to say no, because that's how entrepreneurial businesses are. They need yes, right? But they need yes, let's do it this way. The other example I would give is a company's routine contracts. For example, let's say I'm a home improvement contractor, right? First of all, state law in New Jersey says you have to have a written contract if you're a home improvement contractor. You have to use a written contract. That written contract needs to have 10 different things in it that are specified by law. If you don't use the written contract with those 10 things in it, your client can decide not to pay you, and there's nothing you can do about it. So that's one reason why you really need to have a good contract. But the other reason is that contract is your route to all of your revenue. And I realized years ago, as the lawyer for a vendor, that I, as the lawyer, was actually the sales closer. I was the last person that the customer talked to at my company before they made the buying decision.
Okay.
All right. So that puts a duty on the contract that I write. Those contracts need to be very clear. They need to not scare customers off. And it needs to be very clear what all the sides are going to do. My client wants it to be clear when they have done their job and when they're finished. Like, we've done the thing we said we would do to be paid for, and we don't need to do anything else for you. That's pretty critical to define and to make sure the other side understands it. And so I like to try to develop contracts for my clients that actually that promote their business, that increase the velocity of sales in their business, because they don't have terms in it that trip up a client every time. They don't confuse a client. They don't scare clients away, but also they take care of the issues that have been coming up for my client, the kinds of things that keep tripping them up when they go out to do business. Let's take care of those. Let's literally format the contract in a way that's going to be fastest for your client to agree to it. And these are things that I do routinely that I have to say you will not get if you go to download a contract off the internet, for God's sake.
Which is not a good idea anyways.
Right. Or it's like, well, my buddy has a template, right? You will not, well, you may do more harm than good. And I've had clients I've seen companies that basically failed because they used someone's template.
Yeah.
But more to the point, if you put a little bit of investment into that contract, and I'm not talking about a very big investment. It's a few $1,000s maybe, but that's an investment you're making in your relationship with your customer every single time you go out to make a sale.
You're taking the risk away and like shifting the load and everything. I think this is a good idea. This is a great idea. Definitely not. Don't take somebody else's contract and use it, make it yours kind of. It's definitely not applicable to you. So yeah.
First of all, every business is different.
Every business is different.
Those tend to be, I'll give you one more example, Sanjay, because this is also something that comes up a lot, which is I do represent a lot of companies that are sort of tech or life science startups. They're fast growth companies. They're looking for venture capital money or angel investors. Most small businesses don't. Most small businesses, there's a founder and they're going to bootstrap the growth of their business, and they're probably going to have a very nice life running that business. And it's a great business. But there are some businesses, and they tend to get a lot of attention, that are sort of your Shark Tank kind of businesses.
Right.
There are a lot of forms out there for those businesses that can be downloaded off the internet for how they sell stock to people, how they sign up a co-founder, if they want to give stock to the person who's doing coding or marketing for them, right? Oh, just use this form. Use this form with your investor. They're out there. They're widely available. And they may even be legally sound. That is, they might be the right agreement for the right purpose. But they are almost always way too complex for most founders. And that complexity is there often to benefit the investor class, to benefit the angels and the VCs, because it's an agreement the business person does not understand. People who spend all their life in finance do understand it, and they will use that knowledge gap to their advantage. So even in that situation, I would really say to a company, spend a few dollars, make sure you're signing, and see if you really have to get involved in an agreement you don't understand. And if you read a passage in an agreement and it takes you 2 or 3 times to get through a paragraph, and you feel like you have to go back to diagramming sentences like you were in 7th grade just to understand this paragraph, you need to call a lawyer. And you probably need to call a lawyer not just because you don't immediately understand it, but probably because whoever handed you that contract did not want you to understand it.
It just purposefully is being like that. Okay, I get it.
Yeah.
Makes sense. It makes sense. It makes total sense. This is great information, Jason. I think this is going to be really beneficial for a lot of listeners, because people just put assumptions and go with that. And this is going to be like light bulb comes off at some point for them. Another question which I have, which is kind of switching the gears again, it's about the employee relationship part of it. And one thing which is kind of hot right now is FTC announcing rule banning for non-competes.
Yes.
Just want to hear about non-compete, because this is kind of hot topic right now. We don't have to cover everything. There's a lot of questions I have, but I don't think we have enough time. But this is one of the hot ones. I thought maybe I'll run it by you and see What do you think, and what are your thoughts on it?
Sure.
What does it mean?
I can give you an overview of this area, and I recently did an article about it in LinkedIn for people who want to look that up. But so a non-compete, covenant not to compete, is a provision in a contract that says, and typically it's for employees, but it also can come up for independent contractors. It says, when I stop working for you, I will not work for your competitor for some period of time, usually within some geographic area. So I'm cutting hair for you. I'm a stylist in your salon. When I leave your salon, I will not go to be a stylist at any other salon in the state for a year, let's say. There are already 4 states in the country that say, nope, can't do that. That's unfair. That's just too much power in the hands of the employer or the prime contractor. It's keeping people from really pursuing a living. We're not going to recognize those in the law. The other 46 states do to some extent. They put limits on it. They want to make sure it's reasonable. They are looking for signs that it was fairly bargained, that it doesn't overreach, but it's still generally legal. And that includes in New Jersey. New Jersey considered banning non-competes and so far has not. Well, the Federal Trade Commission came out with a rule a couple of weeks ago that was supposed to go into effect in the summer, that said, that's it. No more non-compete agreements. The only time we're going to allow a non-compete is with a senior executive of a company making more than about $152,000. Look, if you are the chief financial officer for a pharmaceutical company, and yes, that pharmaceutical company can say, we don't want you to go to work for another pharma company for a year. We accept that because there's a lot of money at stake and you're being paid well. There's more equal bargaining power. In almost every other situation, the law simply will not recognize a non-compete. I think for entrepreneurs, that is a fine change in the law. I think that most entrepreneurial companies that I know of did not really want to use non-competes. They didn't want to get involved in the potential cost of enforcing a non-compete. They didn't want to have that reason to have a fight with their employees later. They actually want a better relationship with their employees, maybe a more mentoring or equal relationship with their employees, and more fostering I tend to foster my employees' career more if I'm an entrepreneur, let's say. Also, there are a load of other ways to protect what you need to protect without a non-compete. Let's take the hair salon example. It's very clear under the law who my customers are and what I do for them and how I contact them is absolutely a trade secret for almost every company.
Right.
So I can get my employees to agree that is confidential information and they are not at liberty to use it, to take it with them, or to use it for their own purposes.
Yep.
And to do so would violate a contract and in fact might very well violate various statutes. That law is completely intact and very enforceable.
Okay, that's good.
All right. This new stylist, and I don't want her to set up her own shop in 6 months and go call all my customers.
The solicitation part?
With a few pieces of paper, I can say, you're not allowed to use that information and you're not allowed to call my customers. Right? You can go set up a business, have at it. You can't call my customers.
Makes sense.
Put your ad in Facebook. That's fine. But don't go sending emails to my customers. That would be breaking our deal. That is completely enforceable.
But if the customer wants to make a change by themselves, I don't know. I'm just trying to see that thin line here. Like if a customer saw your ad and came over to you versus work with somebody else, then that's fair. That competition. You're not soliciting. It's a customer making a shift. That's their choice.
And that does this create a problem when you're trying to enforce your trade secrets provision?
Yeah.
Yes, it can. Are there areas where it's a little harder to enforce? Yes, there are. But if you do your paperwork right, not so much. And then not so much is part of it is when you hire people and as you train those people, you make sure they really understand what their duties are and what their obligation is from the beginning. And most people will try to obey their obligations and know that life is too short to go burning bridges with former employers.
Yeah. Yes.
The other reason I don't mind this FTC ban on non-competes is it actually will probably lead to more entrepreneurial activity because the typical non-compete provision says not only can you not go to work for my competitor, you can't start a company and compete with me.
That is interesting.
Which is a real problem if you've been working in marketing or consulting or personal services. Yeah. You're basically forbidding me from becoming an entrepreneur. Or if I want to be an entrepreneur, I have to take a year off and I don't know what, drive Uber for a year, and then I can finally go start my marketing company. And that was one of the things that really got the FTC's attention. And it said people should really be free to leave, to stop being an employee and to start being a business owner. And the FTC rule specifically says you cannot have a non-compete that says you're forbidden from leaving and starting a competing business. And they estimate that this will lead to thousands more small businesses actually being founded. And I think that's great for the small business community generally.
No, I agree with you. And I think there is a lot of implications when somebody is kind of on a visa and they just got a green card or something and they're working for a company, which would be IT company, because I've had associated, you cannot work on the same insurance company. It's a non-compete. Yeah. I work for an insurance. I cannot work for any other insurance company. I was an IT guy. I'm working for something. If you have an NDA or something, that's different, but I should be allowed to work. And a lot of people, I know a couple of my friends from the IT, they have to just switch from an insurance to something else, which they didn't like it at the time, like 20 years back. And they were not happy about it. Some of them even left, like, I'm going back. I don't want to work on this one. I'll work from home, wherever that is. So yeah, this would be a great thing, which I think FTC has done. So I'm pretty happy.
Yeah, and the thing I'll add about this, Sanjay, is that there's already a court challenge to this new rule, as is typical for almost any new regulation. There's a lawsuit to stop it.
Yeah.
But I think even while that regulation is in doubt, there is an opportunity here if you're leaving a company, frankly, just to go to your employer and say, look, this is the kind of thing I want to do. Is there really a problem? Like, are you going to enforce a non-compete against me? And I think most large companies at this point go, no, that's not the kind of thing we're worried about. We're worried about, what are they really worried about? They're worried that you're selling Xfinity wireless to the very largest companies, and you leave and go to Verizon to sell wireless to the very largest companies. Okay, that's really what a company is worried about, and they probably won't give you permission. They're probably going to try and stop you from doing that. And when it comes to trade secrets, they probably have a pretty good case anyway.
Yeah, no, not proprietary information is something they're kind of worried about, not really like general kind of things.
Right. But if I'm, I don't know, driving a maintenance truck for Xfinity and I want to go take an office job at Verizon, who cares? And chances are, I use these names without having any idea what their business policies are. So accept it as hypothetical. But my guess is if you went to your boss, and you said, I've been driving a maintenance truck for you, but I'm going to go work this office job for Verizon, Xfinity would say, fine. Yeah. Have a great life. Good luck to you. Looks like a better opportunity for you. Go for it.
I agree. This is interesting. This is very interesting. I think we might be running out of time also. So one quick question. I'm a digital marketing guy interviewing you and trying to understand that what kind of digital marketing strategies you think you're using, or you can use it, or you will use it to make sure that this kind of powerful information you have reaches out to the customers. What do you do for that? Because I believe that a lot of people are not even aware of all these things. And what kind of strategies you use on your businesses?
Yeah, there's some things I'm pretty happy with, and then there are other things that I feel like I could do a better job with. Mm-hmm. I maintain a pretty active LinkedIn presence. I'm comfortable with the level of civility and dialogue on LinkedIn. Mm-hmm. It's very rare for LinkedIn to sort of, go off the rails into a really contentious discussion. Yeah. And because my business is more of a B2B business, in a way I'm business to consumer because I want to catch you when you're starting a business. But,
right.
Technically it's a business to business, what I do. And I find LinkedIn the most good way to do that. And it's pretty rare that I get somebody who says, hey, I saw you in LinkedIn, so I thought I'd give you a call. But what I hope I am getting out of LinkedIn is some top of mind. And I try to engage in LinkedIn by sharing information and thought leadership through those platforms. So I maintain a personal LinkedIn and also one for each of my business, and try to play those off of each other. And I get some help doing that. I think the other thing to me, as I just look from the outside at digital marketing, is ultimately the name of the game really needs to be that you're getting people's email addresses, because it's sort of the only thing you own. If you're counting on using a platform, Google AdWords, Facebook advertising, whatever else, you're really still at the mercy of whatever that large provider is doing with their algorithms and with their payment processes and how they rank you versus larger businesses, and what this week's newsfeed looks like. The thing you can own is having an interested person's email address and the permission to use it. And then you can begin to do email newsletters and things like that, which is something I probably should be doing more of. I used to do more things like Twitter. I don't so much now because, again, the conversation sort of degraded. And frankly, I'm not sure that it ever really drove business as much as it was just sort of a fun game to play.
Yeah, no, it's kind of a simple way to say that if you are doing marketing in a general way, try to do it omni-channel, because one channel may not be enough to reach out to all the prospective customers. I mean, omni-channel is obviously a better one. Like if you're saying email, then a LinkedIn, then a Facebook, and a website, together they will generally work better versus just beating up one channel only and expecting like miraculous results. That generally, I've not seen that happening in my lifetime. Like, oh, one channel works fine. I mean, unless something goes viral, that's different.
Yeah, and it depends what kind of business it is.
Correct. That is also very true. Very true. Cool. This has been a great conversation, Jason. One thing before I go, I just want you to, I'm sure that there are a ton of more questions our listeners are going to have. If you can provide the details of how they can reach out to you, your phone number, your email, your website, that would be really, really be helpful to the people, anybody who wants to reach out for further discussions or consultation with you.
Of course, I would be delighted. So my website is meyerbusinesslaw.com, and there is a contact form on the website if you want to try and reach me, and we do try to post resources and links to things on the site as well. So my email address is Jason Meyer, JasonMeyer at meyerbusinesslaw.com. And that's often the best way to reach me, but my office phone is 609-534-3535.
Great. Thank you, Jason. Thank you so much for your time, for all of this wonderful education session. I love it. Thank you.
Thank you, Sanjay. Really appreciate the opportunity.
Absolutely.
Thank you for tuning in to today's episode of Pioneers in Pixels. We hope the discussion was enlightening and informative, giving you a clearer insight into the complexities. Remember to subscribe to our podcast on your favorite platform and never miss an episode. Join host Sanjay K Khetarpaal next time for more insights and interviews with leading legal experts. Until then, stay informed and empowered. This has been Pioneers in Pixels. Thank you for listening and have a great day.